Thank you.
Good afternoon, ladies and gentlemen. My name is Kamil Szpyt. I have a pleasure and honor to be a moderator of this last panel today. So as a first will be Mrs. Claudia Ribeira Pereiro Nunes and Camila Pinto Barreto da Silva with their topic, Brazilian regulatory challenges and perspectives for patients' privacy on body images on health artificial intelligence systems. I'm afraid. I see Mrs. Camila Barretta is with us. Here. Oh, please, Ms. Barretta, unmute yourself.
Thank you. now it's okay. It's a pleasure to stay here. My friend, my colleague have a problem, a personal problem. His husband had an accident, so Claudia Nunes will not be here today. So I will present this resume. Okay, this abstract.
Yes, of course. The floor is yours.
Yes, I am a postdoctor in law and technology in Reggio Calabria, and my discuss here will be regulatory challenges in Brazil and perspectives for patient privacy for image examination in artificial health intelligent system. Okay. Technology has advanced immensely in recent decades, and with it, the use of AI in artificial intelligence has come to guide decisions and executive tasks. Artificial intelligence has been used to optimize and automate human activities, and it can be applied in different contexts. It is possible to visualize the potential for artificial intelligence to make major changes in healthcare. It can accelerate the creation of new drugs and therapies, reduce material and financial waste, expand access to healthcare, improve clinical analysis, among many other activities aimed at promoting social well-being. Artificial intelligence is so real that even during the COVID pandemic, it collaborates with geography monitoring all contagion curves, discussing confirmation and the development of the first vaccines and drugs available. And even though artificial intelligence brings advance, we cannot forget about possible harms. It may carry out some not so possibility activities such as ostensible monitoring, discrimination, privacy violation, and others. Considering the protection of personal data in health, artificial intelligence can cause irreparable damage. Hence, the importance of establishing safe, ethical, and normative parameters for its use. Checking the relevant and importance of the topics, nationals and economic blocs such as Brazil, the US, and European Union formulated proposals to regulate artificial intelligence. This is where we come across the questions of this article. That be questions, discussions, and new ideas that may be useful for advancing artificial intelligence regulation. In this context, what is the Brazilian regulatory approach to the development of artificial intelligence system in healthcare for patient imaging, example, tomography? In Brazil, Like so many other countries, the regulation of digital health is incipient. Moreover, it is worth noting that the country carry out regulatory procedures when implementing the general law for the protections of personal data and the ANVISA, a regulatory organ, resolution for the regulation of software such as medical devices. Our legislation for privacy specific is extremely important for digital health as it uses different databases, both public and private, of different dimensions and make use of sensitive data association with personality, rights such as intimacy, privacy health, among others. The law, the privacy law establishes an exception to the treatment and share use of data by the public administration and everything of public policy execution. It also provided that in the event of public health studies, research body may have access to personal data and whenever possible, the anonymization and pseudonymization of the data, as well as considering the due ethical standard related to studies and research. And the institution of ANPD came with the proposal of inspecting, enforcing the privacy law. ANVISA regulation 657 of March 2022 provides for the regulation of software as a medical device. It sets the artificial intelligence risk grades and different rules for different risks. In other words, high risks will have more intensive control by ANVISA. The regulation was instituted considering the risk of the software and wherever the software is effective and clinically beneficial to health and listed that the regulation does not apply to wellness software. ANVISA's resolution represented a major regulatory breakthrough in the field of digital health. It remains to be seen how this resolution will be applied in practice. Furthermore, the Brazilian government instituted the Brazilian Artificial Intelligence Strategy with the objective of stipulating governance norms and procedure that ensure compliance with the fundamental principles of the constitutional order. One of its assumptions being that machine learning processes must be traceable and subject to human review. In conclusion, we have that the need to regulation of artificial intelligence must be proportional to the degree of concrete threat of each system. An efficient regulatory policy must take into account the algorithms with the highest and lowest of safe potential, including what is included in the ANVISA resolution. Artificial intelligence systems that use machine learning are subject to a more stringent legal regime. Digital health and artificial intelligence applied to health have immense potential benefits for society. Also, there are risks both for individual and collective health. In case of no existence of norms or doubts in their application, ethics and morals must be considered. In bioethics, we have the principle of non-maleficence that seeks to minimize the risk and or harm to the patient. That is, It's up to programmer and or coder owner to carry out a TAWAS test. That is it.
Thank you very much. Thank you for the presentation. This is so for this interesting presentation. And the next one, my friend from the Polish team, Dr. Aleksandra Partyk, with her presentation, Human Judges versus Artificial Intelligence in Legal Cases Concerning Medical Errors, some remarks.
Good day, everyone. Am I heard well?
Yes, very well.
Yes, so
You look very well and you sound very well.
thank you very much. Thank you for being here. We spent a few hours today and yesterday at the university, but now the time to be online. So today I will be talking about something connected with my interest and my nowadays research, which I'm talking about law and psychology and the interface between. And my speech will be connected to the artificial intelligence problems also in the sphere of ethics. In my speech, I will also concerning the Polish legal regulation that are very tricky because the judge has a wide scope and he can do many different things, like organizing the case, connecting the patient who had some injuries, and there could have been some errors. So we will be talking about Polish civil code for some minutes, and then we will be talking about I will be talking about the research I'm taking on, and it is connected with judges. I'm interviewing judges, and some of them answered my questions about their attitude toward artificial intelligence being like a judge. So I would like to show that their attitude is quite different than we may believe it is. So pursuant to the section of Polish Civil Code, a court of law may grant to the injured party a relevant amount on account of pecuniary compensation for the wrong suffered. There's also a special provision when the closest family members of a dead person would like to be given compensation. So we've got many regulations concerning compensation, and according to medical errors, these two regulations are the most important, and the court may award an appropriate amount, the law says. So we have got just information about appropriate amount to a person that should be given money, and there is no possibility to find out what is this appropriate amount. Is it, for example, 1 million zlotys, 1,000 zlotys? We never know what can be treated like appropriate amount in any case. And of course, there are many cases concerning medical errors. Of course, it depends on many factors, but there are many cases concerning a patient who believed that in his case there were some bad decision of a doctor, of a nurse, for example, and we have got many cases like that. And during such cases, the court is to decide if there was this error of a doctor, for example, and then to decide on the appropriate amount if he or she decides that the amount should be given to the injured person. So in such cases, possibly there are many decisions that can be taken. We can imagine then in quite familiar cases, different sum of money would be paid to the person, to the plaintiff. And the law says only about appropriate amount, so we never know what the judgment will be. And during this this topic, we may understand the problem when scientists are talking about artificial intelligence in courts while adjudicating cases, because we can believe that when artificial intelligence is a judge, maybe the rulings will be the same in every case. We never know that. But in my opinion, it is not a great idea. Of course, artificial intelligence could do a great help during the work of a judge, but in my opinion, it is not the best idea to replace artificial intelligence in the seat of a judge. And I would like to show what the judges with whom I talked recently talked about it, because during my research, which is connected with psychology, I'm talking to judges who are anonymously presenting their view on different topics. And during one of these researches, I was talking about the problem of emotions, and also in the scope of the questions asked, there was a problem of artificial intelligence. And I must say that the persons with whom I was talking were not a monolith, and some people, some judges had more or less the same point of view, but not every one of them had the same idea on this case. So I must say that I didn't speak to many judges on this topic, but a few of them could answer my questions, and we may see how it's looked like in their eyes. So one of the judges stated that in his opinion, every judge have their online experience and decide according to their experience such cases. It's always unique, as he said, and therefore the decision of a judge is always unique. And he was not a great fan of artificial intelligence adjudicating cases. And he also stressed, for example, that in compensation cases, it is a matter of measure, and every judge can measure all these factors which are important, and to find the best solution of a case. And even a small calibration, a small measurement, in his opinions, is important and should be done by a human. Another judge with whom I was talking stated that in her opinion, involvement of human being in judiciary is a must. The person stated that, of course, in some cases, artificial intelligence could be a great help for a judge, for example, and could also maybe, in her opinion, adjudicate in some sort of cases. But more or less, she pointed out that there are so many things that we have to concern, and it shouldn't be, in her opinion, done by artificial intelligence. So, as we can see on these two examples, they were not great fans of this idea. But I also talked to another judge, a young one, who was actually waiting for artificial intelligence in courts. And he believed that in some cases which are repeated, it can be a great help. He was not talking about cases concerning medical errors, but maybe as he was rather positively seeing the problem, maybe there are some judges who believe that artificial intelligence could somehow adjudicate in such cases. Of course, judges are not monolith. Some of them may have got different attitudes towards it, towards changing the law in such a case. But I think before we could, in one day maybe, change some regulation and let artificial intelligence work in court, not only to help, but also to do something on their own. I think that also in the debate, we should take on the account the opinions of judges, because they know what is important during solving such cases. And lawyers who aren't judges may look at it on a different way. And if we have got a plaintiff, for example, who is a human, in my opinion, only human may understand his problems, which he's talking about. And in cases concerning medical errors, there are many problems that a patient can have. And in my opinion, the way that we maybe one day change the idea of adjudication and let artificial intelligence to solve such cases is not the greatest one. But in my opinion, to some extent, artificial intelligence could be a great help when a judge is to decide on a case, but have the possibility to use all the benefits of artificial intelligence also in cases concerning medical errors, which we may have more and more as we were listening to many presentations today. We could hear about the medical devices that are used connected with the technique. And I believe that we will have many difficult court cases concerning many difficult errors, which could have harmed people. So thank you very much for your attention. It was a great pleasure to be here with you. Thank you.
Thank you, Dr. Bartik, for a great, very interesting presentation. For now, our third speaker, Ms. Leila Fatima dos Santos. Leila, I could see you. You are with us. Could you unmute yourself? Oh.
Olá.
Olá, olá.
Olá, tudo bem?
Tudo bem. Thank you very much. Leila, the floor is yours. And so your presentation, Human Intelligence in the Universe of Artificial Intelligence, a dialogue on law, health, and of course, technology. Very interesting topic, and I think so, very interesting presentation. The floor is yours.
Sim, então, eu falo aqui do Brasil, meu nome é Leila Fátima dos Santos, como foi falado. Eu sou estudante de Direito e estou desenvolvendo uma pesquisa, então, sobre inteligência artificial, né? Já sou formada em Filosofia, então, é um assunto que me interessa muito e venho pesquisando, já fiz o meu TCC. Então, eu falo sobre a importância de dialogar sobre este assunto, sobre quanto a inteligência artificial vem interferindo na vida das pessoas e o quanto ela está presente já também na medicina. Então, nós devemos, como operadores, futuros operadores do direito, falar da importância desse assunto. Então, nós vemos que a inteligência artificial, ela, aqui no Brasil ainda, a gente enfrenta muitos problemas, né? E, olha, que nós temos ainda, os marcos regulatórios ainda são bastante deficientes, e as nossas leis ainda, justamente porque a tecnologia ela é bastante acelerada, ela anda a passos largos, então, infelizmente, o direito ele não consegue acompanhar. Então, a minha pesquisa ela tem como fundamento trazer um pouco sobre a responsabilidade em relação a quando acontece alguma espécie de acidente, quem é responsável? Nós podemos apelar para o direito do consumidor, entendendo que essas máquinas, os robôs, eles seriam apenas máquinas e que, se acontece algum acidente, seria tratado no campo no campo do direito do consumidor, ou nós poderíamos tratar no campo da responsabilidade civil. Então, esse é um assunto bem complexo, e eu trago, então, essa interação da tecnologia e homem, muitas vezes ela fica meio que confusa. Eu fui pesquisar, e está no meu artigo, sobre toda a história da robótica e como ela vem se desenvolvendo, e nós vemos que nos hospitais já é bastante usado os tipos de robô, que o principal é os robôs da Vinci, que já fazem vários tipos de procedimentos, e alguns procedimentos que são, muitas vezes, que... E até a própria Vinci, ela adverte, né, que alguns procedimentos realmente podem ocorrer algumas falhas, e se essas falhas ocorrem, qual é a responsabilidade né, da parte médica, da equipe médica, e qual seria a responsabilidade, então, de quem organizou, programou a máquina? Esse é o principal motivo da minha pesquisa. Nós aqui no Brasil agora, nós tivemos uma lei que foi 2021, e está trazendo, né, essa regulamentação, e trouxe alguns procedimentos que devem ser adotados pela área médica, mas ainda eu entendo que tem muitas falhas ainda. E também nós temos toda a parte, nós devemos também pensar como as pessoas, né, porque a gente sabe que os procedimentos feitos pela inteligência artificial que utilizam a robótica na medicina ainda são procedimentos bastante caros, e que muitas vezes não são acessíveis para aquelas pessoas que têm menos condições, que têm menos renda. Então, como fica a questão social? Então, eu trago também essa questão da ética, o quanto nós estamos propícios, né, a essa evolução, e essa evolução ela vem causando também uma espécie de desigualdade, uma desigualdade social. Isso é bastante preocupante. Então, eu trago alguns dados da minha pesquisa, mas a gente viu agora na pandemia que foi bastante importante a inteligência artificial estar presente na medicina, e ela avançou bastante. Através dela se descobriu logo alguns tipos de vacina, e a gente viu que a gente precisou também dos respiradores, que foram controlados, de certa forma, também pela inteligência artificial, e que a gente entende que é bastante importante, que é necessário, mas nós também precisamos prever quais são os riscos que essa inteligência artificial nos traz. Eu ouvia um colega falando sobre a responsabilidade, e que muitas vezes falhas acontecem. Eu trago um caso que aconteceu na Rússia, e que viralizou nas redes sociais, que é um menino que é jogador de xadrez ali, que tem o seu dedo preso por uma pinça de um robô que está jogando com são três crianças. Então, ali é uma cena bastante forte para olhar, mas nós nos perguntamos, eu me pergunto, se os pais resolvessem acionar judicialmente, acionariam a quem, né? Acionariam quem estava promovendo o evento, ou então quem programou a máquina? Então, essa é uma questão que eu trago no meu estudo, que é como nós vamos visualizar isso, sabe? Tendo em vista que o erro ele acontece, tanto o humano, mas as máquinas também, né? Por falha de programação ou não, porque muitas vezes o que acontece com a inteligência artificial, ela vai se auto também controlando, né? Algumas coisas vão se adaptando, ela mesmo, dependendo, vai adaptando. Então, o quanto os programadores, quem faz os algoritmos, eles estão, até quando fica sujeito a eles a programação, e a partir de quando que essa máquina ela começa por ela mesma a ter seus movimentos. Então, fica bastante difícil na área do direito, e quais seriam os princípios éticos quando nós nos submetemos a essa intervenção que não é mais, né, por mão, é sim mas a partir de manuseio, e não mais, às vezes, ali toque do médico. Então, nós pensamos que ainda, até que se tenha um marco regulatório mais, que dê mais amparo para as pessoas, ainda assim tem que ter uma equipe médica ali junto, né, acompanhando para que, se ocorra qualquer falha, para que os profissionais humanos estejam ali para socorrer, para que nenhuma vida fique em risco. Essa é a maior preocupação. Então, eu defendo esse trabalho, né, como forma de diálogo, para que nós possamos seguir em frente, entendendo que a inteligência artificial, as máquinas são necessárias, mas também que nós temos que olhar e saber que nós somos humanos e que nós temos que ter certos cuidados. Eu trago uma frase bem rapidinho aqui do Donald Booth, que ele observa que a inteligência artificial ela é um sucesso até agora em fazer essencialmente tudo o que requer o pensar, mas falha ao fazer a maior parte daquilo que as pessoas e os animais fazem, que é pensar. Então, nós somos pensantes e as máquinas são aquilo que aquelas pessoas pensantes construíram. Então, isso nós temos que averiguar bastante quando vamos falar de inteligência artificial, leis, né, e ética na área, inclusive na área médica. Essa foi a minha apresentação, então. Eu agradeço, muito obrigada.
Thank you very much for a very interesting presentation, especially about the thinking machines. So the next one will be Isa Filipa Antonio de Sousa from University do Minho in Portugal, with her presentation, Violência dos Direitos ao Determinação da Mulher Grávida, parturiente do direito ao conhecimento informado, retrato da violência obstétrica em Portugal. Excuse me for my Portuguese. I know it's not very well, but all people laughing. Okay, yeah. It's good one.
Olá, muito boa tarde. Peço desculpas, estou com problemas técnicos desde o início da tarde. Good afternoon. Hello. My presentation will be in Portuguese. I'm sorry for that. Portanto, eu hoje vou falar, muito boa tarde a todos, vou falar de violência obstétrica, o retrato português, o estado da arte deste fenómeno em Portugal. Na verdade é um fenómeno que já é muito conhecido no Brasil, já se fala há imenso tempo no Brasil. Eu tenho mestrandas com teses sobre isso, que são brasileiras, e dizem, professora, já há muito tempo que temos esta discussão na nossa sociedade civil, mas a verdade é que em Portugal começamos a dar os primeiros passos nesta matéria, porque apesar de as mulheres serem objeto de violência obstétrica, não têm tido a consciência de que essas más experiências durante o parto têm um nome, que é a violência obstétrica. A violência obstétrica pode ser traduzido em termos mais simplistas sobre qualquer forma de atuação sem o consentimento da mulher enquanto doente, desde logo, e que tenha como resultado qualquer dano causado a nível psicológico ou a nível físico. Portanto, é critério essencial para qualquer prática de ato médico o consentimento do doente. Assim mandam as regras da profissão médica, o Código Deontológico dos médicos tem consagrado a autodeterminação do doente, tem consagrado a necessária obtenção de consentimento do doente antes da prática de qualquer ato médico, mas na verdade, quando chegamos à obstetrícia, verificamos que em muitas destas situações o consentimento da mulher não é obtido. E desde logo também ao nível do direito à informação clínica que é prestada à mulher, no âmbito do parto também não é um dever que tem sido cumprido pelos profissionais, porque também falta conhecimento a estes profissionais que a ausência do cumprimento do dever de informação e obtenção de consentimento, na verdade, constitui a prática de um crime, que é o crime de tratamento médico arbitrário. Está previsto no Código Penal, sendo certo que, no caso de certas práticas no âmbito do parto, como a episiotomia, poderá mesmo consubstanciar a prática de outro crime que está previsto também no Código Penal, que é a mutilação genital feminina, e em situações limite, causando ofensa à integridade física agravada da mulher, em virtude das sequelas causadas por esta prática, e eu gosto de falar a lesão do nervo pudente que tira o prazer sexual para o resto da vida, que tira a sensibilidade a nível sexual, mas não só, causa dores crónicas para toda a vida, que a mulher pode ficar incontinente urinária e fecal, pode ficar com infecções. Portanto, há muitas sequelas que resultam da episiotomia, que é uma prática rotineira, cerca de 70% diz a associação que representa as mulheres grávidas e parturientes em Portugal, 70% dos hospitais portugueses praticam episiotomia, podendo levar estas sequelas para a mãe e podendo correr riscos o próprio feto. Mas é importante referir que não é obtido o consentimento das mulheres para esta prática e a Organização Mundial da Saúde já foi muito clara. A episiotomia, que é o corte da vagina para facilitar a saída da criança, representa um crime contra os direitos humanos, representa uma mutilação genital feminina. E quando nós falamos nestes termos, talvez tenhamos a real percepção do que está aqui a ser praticado nos hospitais, não é? O crimes contra os direitos humanos. Que de resto a Convenção de Istambul, também no seu artigo 38, e agora estou a especificar, fala que a mutilação genital feminina é desde logo praticar a excisão, infulação ou qualquer outra mutilação total ou parcial, portanto da vagina, que é uma prática médica no âmbito do parto. E refiro e sublinho, sem o consentimento da mulher. Portanto, esta é a prática, uma das práticas muito perigosas que são feitas em sede de parto, mas também existem outras, como a manobra de Chrysler, que na verdade é empurrar com o cotovelo o bebê, portanto colocar em cima do bebê um cotovelo para ele sair, para ser expelido pelo canal vaginal, e que em muitas das circunstâncias causa lesões cerebrais à criança. Portanto, a violência obstétrica tem dois vetores muito importantes, não só a violência contra a mulher, fica porventura traumatizada para o resto da sua vida, como sobretudo também, porventura, contra a criança que vem a nascer, que poderá nascer com sequelas. E a questão que se pergunta é, mas existem outras formas de se alcançar o mesmo resultado? Que é fazer o parto? Existem outras formas. Não sou eu que digo, não tenho conhecimentos científicos, muito menos médicos, mas existem estudos que dizem que é uma prática que tem sido exacerbadamente utilizada e que existem outros caminhos. Por outro lado, para demonstrar a realidade portuguesa, entre 1 de janeiro de 2012 e 31 de março de 2015, há dados mais recentes, mas vou ser honesta intelectualmente, estes são os dados que eu tenho. A associação que representa as mulheres grávidas e parturientes referiram que não houve consentimento da grávida em cerca de 29,7% no caso da episiotomia, 22% na ruptura da bolsa de águas, que praticamente 18% foram feitas cesarianas sem autorização da mãe e cerca de quase 12% que houve medicação para acelerar o parto, como a oxitocina, sem também o consentimento da mulher. Hoje em dia as pessoas estão mais informadas e levam o plano de partos para os hospitais. Quem está informado leva o plano de partos, em que a própria Organização Mundial da Saúde tem umas recomendações, em que em que são dadas indicações aos médicos e à equipa profissionais, também às enfermeiras. Nós não falamos muito das enfermeiras, mas têm um papel muito importante no parto, mas a verdade é que colocam do lado, riem-se na cara das mulheres, e ignoram completamente, alheios àquilo que estão a fazer. Colocar de lado o plano de partos é, na verdade, violar o direito à autodeterminação do doente, violar o direito da pessoa ter o parto que deseja, que é um direito humano. A própria dignidade da mulher é colocada em causa, e sendo certo que vários princípios caros à bioética, como o primado do ser humano, o princípio de beneficência, o princípio da maleficência, o princípio da autonomia da mulher, são de uma assentada violados. E isto, infelizmente, ainda é mais grave quando pensamos que a Ordem dos Médicos não reconhece esta realidade. Portanto, eu também tenho no meu artigo que é de publicar um excerto do parecer da Ordem dos Médicos do Colégio de Ginecologia sobre esta realidade, se existe violência obstétrica ou não, e eles negam completamente. E o problema também é aquilo que não aceitamos, aquilo que não reconhecemos, não podemos alterar. E a verdade é que cada vez mais existem relatos da violência exercida. A violência pode ser sobre pode assumir muitas vertentes, muitas vestes. Não só é a violência física por ação, mas também por omissão. A negligência na vigilância da mulher, a vigilância na monitorização do feto. Existem relatos de mulheres que são deixadas à sua sorte a gritar com dor durante várias horas, até haver a decisão de se proceder à cesariana. Curiosamente, no Brasil, de acordo com os relatos das minhas mestrandas, há um excesso de cesarianas. Não sei se têm... Pronto, aqui temos ao contrário, tem-se o entendimento que as cesarianas saem muito caras ao Serviço Nacional de Saúde, então deixamos a mulher aguentar para além do limite até que façamos a cesariana, mas também a medicação, o excesso de medicação ou medicação sem o seu consentimento. Relatos de insultos à mulher enquanto está a ter a criança. Portanto, isso são factos e não podemos, são testemunhos e não podemos negar uma evidência. Portanto, a Convenção de Istambul está a ser amplamente violada, a própria Convenção de Biomedicina está a ser violada porque estabelece regras muito, muito claras sobre a necessidade de obtenção do consentimento. As regras elementares de bioética que devem orientar a prática dos profissionais de saúde está a ser completamente ignorada. E em Portugal uma deputada chegou a apresentar um projeto de lei para criminalizar a violência obstétrica, portanto haver um crime específico para a violência obstétrica. Não, neste momento está parada esta discussão, mas eu creio que seria uma mais-valia, um passo em frente a criminalização desta conduta, porque efetivamente estamos a falar de direitos humanos, não só da mulher, mas da criança por nascer. Qual é a questão? A realidade portuguesa em termos de jurisprudência é que quando a mulher, a mãe ou os pais propõem uma ação judicial contra o médico, a equipa médica ou o estabelecimento de saúde, é por erro médico, ou seja, situações mais graves de falecimento da criança, ou a criança tinha tudo para nascer saudável, nasce com paralisia cerebral porque devido à falta de oxigênio, devido à falta de assistência durante o parto, e então não é por violência obstétrica. As ações são propostas com base em erro médico. Algumas situações são de wrongful life, wrongful birth. A questão deve ser distinto, porque são questões que se prendem já com um erro e com negligência ao nível do diagnóstico, erro médico ao nível diagnóstico durante a gestação, mas a omissão de informação também redunda em situações muito, muito graves para a criança, porque nasce com problemas, nasce com doenças e malformações, e os pais têm o direito de acordo com a lei, o direito reprodutivo de interromper a gravidez, nesses casos, até às 24 semanas de gestação. Mas são situações que vão aos tribunais, quando temos wrongful life, wrongful birth, ou seja, wrongful life é a própria criança, é a representação, são os pais que representam juridicamente, judicialmente a criança, mas é uma vida, isto é polémico dizer, mas é uma vida que não devia ter existido, porque é uma vida de sofrimento, e a criança, representada pelos pais, vem pedir uma indemnização pelas angústias, sofrimento físico e pelas despesas materiais que vai ter o resto da vida, com despesas médicas, com internamentos e com todo o tipo de apoio, porque estamos a falar às vezes de crianças de 93% de incapacidade, nascem com o corpo todo virado. Mas isso são situações que têm ido a tribunal, ainda não foram a tribunal por violência obstétrica, isso ainda, porque a própria pessoa ainda não tem essa consciência, não é? Mas quando numa assentada só, estão a ser violados imensos direitos constitucionais e humanos, como eu referi. É só perante a presença de erros médicos, da mulher ficar com sequelas graves físicas, é que existe é que se verifica essa propositura da ação. Portanto, a nível civilizacional, se quiser, ainda temos muito a fazer numa matéria tão importante para a própria humanidade, que é o momento do nascimento, que é uma coisa impressionante. Temos que dizer que as mulheres não devem ser insultadas enquanto estão a ter crianças, não devem ser negligenciadas enquanto estão a ter crianças, e que deve-se perguntar, quer fazer isto? Deixem-nos fazer isto? Quer dizer, parece que estamos no século XXI, mas esta é uma realidade muito presente. Mas em Portugal só se começa a falar agora, já no Brasil já há muitas décadas, há várias décadas que se fala disto. Não sei se aqui a doutora Bruna quero depois falar um bocadinho sobre isso em sede de debate, mas da minha parte o meu modesto contributo é este, ou seja, é apontar a crítica e o dedo ao sistema médico, à ordem dos médicos, que devia ser uma ordem isenta e objetiva, mas nisto não se revela ser, e a questão do legislador, a ausência de criminalização também é uma falha muito grande do Estado legislador. Pronto, era isto que eu tinha para dizer. Muitíssimo obrigada e peço desculpa por falar em português, mas eu jamais conseguiria dizer isto em inglês. Muito obrigada, boa tarde.
Thank you very much for a very interesting presentation. And the next one is Bruna Francesnici. Excuse me for my Portuguese and I spelling your surname. I'm afraid it's not brilliant. Okay, but from Faculdade de Direito da Universidade de Coimbra, of course, Portugal, the relevance of the co-creation sessions in the development of technological solutions for active and healthy aging. The floor is yours.
Hello, good afternoon, everyone. So, yes, my name is Bruna Franceschini in Italian, if you would like.
I remember.
So, actually, I would ask your permission to also speak in Portuguese, if it's okay, because I think we have an audience of Portuguese speakers. Do you understand Portuguese? It's okay?
I don't understand, but a lot of audience understand. But of course, the floor is yours, so your decision.
No. So, okay, I'll go ahead in English then. No worries. Actually, I'm still recovering from the last presentation from Professor Isa, which I leave the greetings already. Actually, my topic is totally different, so maybe we can keep on debating later on, but congratulations. I think it's a very important topic. And actually, yes, in Brazil, we have already discussed this a lot, mainly in the women's movement. So, but we can talk about this later on. Well, my introduction, I am Bruna. I'm a PhD candidate in law in the law faculty of Coimbra. But today I'm representing Caritas Coimbra as a European project manager. And I would like to present some initial reflections about this article that we intend to publish in the innovation department of the institution. So the general proposal of this article will be to show a little bit about the relevance and the importance of these activities of co-creation in the development of technologies in favor of this active and healthy aging. The general objective will be to relate the concepts of participation, and in the case, active and citizen participation, with the general sections of co-creation and co-design, to say so, regarding the end users as the center of activities, for example, in European projects. We could say that the specific objectives of this article would be to talk about the concept of participation, because we can think of participation in a philosophical aspect, political aspect, social aspect, and so on. We could deepen, and we should deepen in the thematic of participatory design, because co-creation is like the wide perspective where co-design is one of the approaches. We can co-create a lot of things, and co-design is for products, in a very fast way to explain this. Another specific objective would be to expose the methodologies to do these co-creation sessions. And here we can say some focus groups, interviews, interactive methodologies, and even to open space to think of how can we, in this digital world, hear each other. So to think about these methodologies. And then another specific objective would be to show some practical experiences in these European projects that Caritas has been part of. Finally, to draw some conclusions to say if yes or if no, we can say that these methodologies of co-creation sessions are effectively a way to say that it contributes to a participation in favor of this active and healthy aging, or to say even better, to this active and healthy living in a participatory world, and in a place where the will of the people, of the participants, actually overrides the mere development of the technologies. This is a general overview of the article that we intended to publish. But after this, I think it would be interesting at least to talk a little bit of what we have been doing in Caritas. Caritas is an NGO in Coimbra, but it acts in the center region of Portugal. And not only it works with older adults, but it is one of the social responses that it has. And regarding its aspects, it works straight with healthcare services and social care. So through the European projects or national projects, it's a way to somehow improve, or at least try to improve, people's life. And this we can always see in two ways. First, with the end users, which are the primary users, and we try to bring this technology and somehow improve their daily lives. But there is another way, concerning the secondary users, which are the formal and informed carers. And this is a place where we need to think about the workload of taking care of another person. So when we talk about these projects, we always have to deal with these two cases, two possibilities. And these co-creation sessions, they arrived exactly in these perspectives. When we go to a European project, in general, there is a technology being developed, but the center of this project should be the people. So the technology needs to adjust to people and not the other way around, especially when we are talking about older adults. So the co-creation sessions through the co-design is a possibility to make people talk through themselves and somehow to enhance the subjective of participation, and people feel more part of these new solutions that are arriving on a daily basis to the market. So it is a challenge to understand how ethically we can bring these new methodologies that can be really inclusive in this new digital world in favor of this active and healthy aging. I hope I have been at least understandable in all of this. And if you have any questions, I'll be very happy to answer. Thank you.
Oh, thank you very much for your presentation in English. I understand everything. Thanks a lot. So the next one is the presentation of the Professor Julia Stanek from Andrzej Frisch-Modrzewski Krakow University, replacing medical intuition with AI. So Professor Stanek couldn't be with us today. She sent her video, so I just play this record of her presentation for now. Please give me the moment. I hope so you all saw this. Okay. Okay, I'm sharing my screen, and next one should be, oh, here you are.
Good evening, good afternoon. Nice to be here again and take part in this following conference organized by Iberju and Andrzej Frisch-Modrzewski Krakow University. Today, I would like to present some ideas on the influence of the intuition on medical decision making in the context of artificial intelligence. It's quite obvious, at least for me, that artificial intelligence has a huge potential for strengthening healthcare systems and generally medicine. As artificial intelligence research in healthcare advances, the prospect of replacing medical doctors with AI appears closer. It definitely brings a lot of questions and unknowns. Today, I would like to consider one of the reasons why it would be very effortful and quite challenging to replace physicians by AI. Medical doctors consider a huge amount of data. Symptoms, patient records, family history, severity of illness, lifestyle habits, examination findings, and lab results. And use
Excuse me.
Physicians huge amount of data. Symptoms, patient records, family history, severity of illness, lifestyle habits, examination findings, and lab results. And use deductive reasoning to make diagnoses and treatment decisions. All of these mentioned activities could be, to some extent, be replaced by AI, but physicians also have at least two essential qualities that AI doesn't. It's empathy, which is necessary to developing trusting patient-physician relationships. Empathy is imaginative transposing of oneself into thinking, feeling, and acting of another. And currently, AI is unable to emphasize, but empathic AI is in development. And next is intuition. I only focus on the second one, medical intuition. And so the use of intuition in medicine has long been recognized as a part of the art of medicine, and even as representing tacit knowledge essential to good practice. According to the latest research, intuition has a significant impact on medical reasoning and decision making. It shows that clinical decision making is based on the knowledge, experience, and intuition of clinicians. Recent studies suggest that intuition is substantial part of clinical reasoning and supports physicians in timely diagnosing cancer and other serious diseases. And moreover, the doctor's intuition about a particular patient's condition played a significant role in determining how many tests they ordered for the patient. And these intuitions plays an even stronger role during the first day or two of patient's hospital stay, when the amount of data doctors have on patient is less than on subsequent days. That suggests that physicians rely on more than just data for medical decision making. They rely also on intuition. But what is intuition? And how the concept of intuition is understood based on contemporary studies. Generally, on the basis of contemporary psychological research, with regard to intuitive reasoning, two terms appear. It's intuition and insight. It's worth mentioning that there is no consensus on the meaning and understanding of concept of intuition. However, there are some common characteristic features. And first, intuition is understood as non-conscious processing. Second, intuition is automatic, uncontrolled. Intuitive judgments arise spontaneously and cannot be intentionally controlled. Third, an intentional nature of intuition is also described as a fast and effortless process. Fourth, intuition is based on experience, that is, on knowledge acquired during a person's life as a result of many interactions with their environment. And the last, it has the ability to initiate action. Another phenomenon described in the context of intuitive reasoning is insight. This term is understood as an unexpected appearance of a solution to a specific problem. The solution to the problem appears suddenly and ideally suits. This phenomenon is often accompanied by a subjective aha or eureka experience. Those who experience insight have a confidence in the truth of the solution, despite their inability to retrace the steps of thoughts that led them to the solution. It's just like the black box of AI. Nevertheless, there is still not enough knowledgeable information on the insight phenomenon, therefore let's focus only on intuition. Currently, the most promising area in the field of intuitive reasoning is research in the field of neuroscience and cognitive psychology. In the first place, it's worth calling the well-known two-system model of mind by Daniel Kahneman. According to his theory, two separate systems are responsible for all cognitive processes in our brain, System 1 and System 2. System 1 is intuitive, is based on unconscious reasoning based on intuition. Further, it's automatic, rapid, effortless, associative, evolutionary, old. It's also more subjective and value-based. Unlike system 1, system 2 is reflective, is based on conscious reasoning, and is controlled, slow, effortful, deductive, evolutionarism, and is also more objective, group following. As Kahneman puts it, one of the main functions of system 2 is to monitor and control thoughts and actions suggested by system 1. It's worth mentioning that it's debatable whether such two separate systems, elucidate in a complete and comprehensive way all the mechanisms of our reasoning. But still, how does it work? What is the mechanism of intuition? There are also many concepts as usual, but one of the best known is the theory of semantic markers proposed by Antonio Damasio. And in short, semantic markers operate, consciously or non-consciously, as assistants in decision-making processes. In this approach, emotions are connected to intuition. Emotion has a role to play in intuition, the sort of rapid cognitive process in which we come to a particular conclusion without being aware of the immediate logical steps. This doesn't mean that we don't have knowledge about those steps, but that emotions are so quick in providing answers that we don't have to activate too much knowledge. Importantly, that semantic markers is something learned, which is, and this is why the quality of one's intuition depends on how well we have reasoned in the past. But transferring about the medical field, the more educated and experienced doctor is, the more accurate his intuition will. So we come to the beginning. Will AI replace physicians' intuition? I don't think so, but I believe that AI could be an aid to human intuition, just like an artificial system 1 of the two-system model of mind. To sum up, artificial intelligence will not replace physicians. However, I believe that physicians who use artificial intelligence will replace those who don't. Thank you for your attention.
Thank you, Professor, who are absent physical, but with us.
Good afternoon. Nice to be here again and take part in this following conference organized by Berger.
Second one. No, without replace today. Without replace, we have something else. So now the floor is for Mrs. Ana Carolina Stoffer from the Portucalense University, Portugal, algorithms and artificial intelligence, an intersection of cutting-edge technology into the advances of healthcare and criminology. Yes, Miss.
Yes, I'm here.
Yes, you are with us. Excuse me. The floor is yours, Ana.
Thank you. So I'm Ana Carolina. I'm a lawyer from Brazil. I'm specialized in tax and international law, and I'm mastered in legal studies and political science by Portucalense University. Well, I'm trying to hurry a little bit up the presentation as we are a little bit late, but I need to give a little bit of the context of how this paper was produced. Recently, we had here in Brazil a new series on Netflix that is like causing shock here, that is concerning a very violent crime that occurred in the 90s, which was a murder of an actress in Brazil. And it is triggered by curiosity because as I'm a fan of technology, this crime was just possible to be solved due to eyewitness. And when I was watching, I started thinking, well, if it was today, the technologies that we had couldn't be used to have solved this crime more effectively and more in a faster way. And then I started to think and to research about the use of technologies to the perspective of criminology, especially under the circumstances of cold cases. Cold cases are the ones that are not easily resolved or doesn't have answer by the time that it occurred due to the lack of technologies. And then researching about that, I found that two advanced theories related to criminologies. And by searching them, I also realized that the technologies that could help these cold cases could not only be beneficial to criminology, but also to healthcare policies. So this is the context in which this paper was developed. So the first theory that I found out has to do with genes. It has already been stated by researchers and scholars that the criminal people have some genes that leads them to commute the delinquency. So the first thing that I started to think is, okay, so we have technology and very advanced ones that can help map the gene of the criminal people. But when it's scanning and doing the mapping and tracking genes, we can identify these genes that tends to lead to criminal acts, but we can also check in early stages if this person tends to have some illness or some disorder. So one technology can give a lot of advancements and a lot of beneficial developments, both to criminology and to healthcare policies, as knowing the tendency of knowing what's the percentage of likelihood to commit a crime or to have some specific or not disorder. The government can decide which policy is better to develop to reduce criminal rates and also to give better and more effective healthcare service to the population. The second theory regarding the modern criminology has to do with the cognitive science, which Kleber, who is here, is a specialist in neuroscience and could speak better than me about that. But it considered that the brain, the human brain, is not only a compact or a singular organ, but it's a modular organ, and different parts of the brain can bring it up different outcomes. Usually, people that commit very like first or second degree murders doesn't think at that moment with both sides of the brain, as it's already known that the left side is just performance they acted, while the right side has to do with emotion, moral sense, judgment. So knowing this theory also allows the technology to be used to reduce criminal and also to perform better healthcare policies. As it's already known, the math that is behind human brain decision making. So knowing the equalization, knowing the math that has to do with the human brain decision making, it's possible to prevent by having prototypes of the likelihood of someone taking this adult conduct and then prevent this crime, and also to check if it's a case of investing more in healthcare regarding psychology and psychology healthcare to prevent crimes. So the paper is about that, the use of technology, special algorithm and AI in order to reduce criminality and in order to the same use benefits the healthcare policymaking. Thank you.
Oh, thank you very much for a very interesting presentation. I'm looking for Professor Stępień Załucka. She should be last one today, but I think so. She absent, maybe some technical problems. Okay, so I think so. This was last one presentation for today. So for now, I open the discussion. Ladies, gentlemen, maybe some questions. So many interesting presentation. Oh, Mr. Kleber Mesquita. I don't know how you would spell it. Excuse me. The voice is yours. The floor is yours.
Professor, the last presentation is mine because I was included in the final program.
Okay, if you include it, you are welcome to here welcome to our panel. So the floor is yours in this case.
Thank you very much. Thank you very much. I will try to be extremely quick because we are late. I study with Caroline Stoffel in Portugal. I'm here in Brazil. She is a master, but I will defend my thesis only December 5th. So I will try to be extremely quick. Professor Marcelo Yenka from University of Basel in France and Professor Roberto Andorno of University of Zurich, Switzerland, propose new human rights to prevent neutral technology from making abuses of specific brain activity data. This was very well demonstrated in the Netflix documentary, The Great Hack, and it's even better demonstrated by the Professor Carissa Veres and her recent book, Privacy is Power. We know that it's possible to reach and even change brain activity. And we also know that it's possible in social networks manipulate emotions, instigate hatred, disseminate panic or indifference behaviors, raise patriotic feelings, and also instigate feelings of xenophobia. We know that we can stop people from taking to the streets to protest anything if they can protest on social media. As we know, it's possible to use that same networks to shadow and publicize a public protest. That's why we need these new rights to protect ourselves from this kind of manipulation. Basically, these new rights would be the right to cognitive freedom, the right to mental privacy, right to mental integrity, and right to physiological continuity. My work will be dedicated to specifically address how the law would protect human mental integrity from hackers who could interfere with brain implants or other devices connected to the brain to treat injuries and pathologies, controlling human brain or sending signals, taking command of functions until then voluntary or even completely rendered useless. My method will be literature review, mainly, especially papers, articles. Oxford professors Thomas Douglas and Lisa Forsberg draw attention because many states recognize a legal right to bodily integrity, understood as a right against significant and non-consensual interference. So we now need the recognition of analogical legal rights to mental integrity as a plank of the right to freedom of thought. not yet properly developed or applied, especially in this age of nanotechnology. Professor Andrea Lavazza, Italy neuroscientist, agrees that there are moral and bioethical needs that demand legal protection in case of any neural prosthesis. Subsequently, research professors Geoff Keeling, Christopher Burr, both specialists in bioethics, and Professor Cale Gill, philosopher, are also dedicated to justify the need for this legal protection of mental integrity. However, the challenge that was true to me by Professor, I don't know how pronunciation this name, Miftah Zenelaj from Kosovo, was to research how exactly the law could effectively protect mental integrity, since a beautiful statement in a universal pact is not enough. As Professor Norberto Bobbio said, even in the last century, law lacks effectiveness more than laws, declarations, facts. The law cannot be seen as an end in itself, but is a means to an end. My paper is the beginning of the search for this answer, which will reach the to the Rhodes Conference on Bioethics next year, and will continue in my doctorate. Thank you all for listening me until this hour. Thank you very much.
Thank you very much for your presentation and the time discipline. Thanks very much. So now I open the discussion second time. Who first? Ladies and gentlemen. I know it's a little late, but presentation were so interesting. One. I'm afraid too much emotion for today, so I'm looking for Professor Stępień Załucka. I can find her. Okay, ladies and gentlemen, if have any questions, so I have the honor and the pleasure to close this conference. Not only the panel, but all the conference. Thank you very much for your presentations, for your online present in Krakow. Thank you very much, and I hope so we see on the next time for the next year. And in my opinion, it should be personal in Krakow. Be our guest. Have a nice day. Have a nice night. Thank you very much for one more time. Bye. Dziękuję. Gracias. Goodbye.